Okay, folks, welcome to Fire's monthly webinar. It's December. Happy holidays. To returning members, I think you all know how this goes. It's member-driven questions. So I do a little bit of framing here at the beginning. You all can go to the bottom of your screen to the Q&A button and start typing in your questions about any free speech-related matter. And we do our best for the next hour to get to as many of them as we can. I think there's been 1 month where we've gotten to all the questions. We're going to aim to achieve that goal here again in December as a holiday gift to all of you. But we have many new people coming to this monthly webinar because we did open this webinar up to the general public as a way to entice the public to become Fire members before the end of the year. These, again, are monthly calls that we've heard from our members you guys enjoy. So if you like this call, you like doing the Ask Fire Anything deal, please consider becoming a Fire member before the end of the year. What does membership get you? It costs $25, but it gets you access to these webinars, these monthly webinars, Fire events that we host across the country. You get access to our quarterly publication, comes to you in the mail, and you get a Fire membership card to show that you're a member of the free speech movement. So
Nico,
please, yes.
That sounds like it would be a great gift for loved ones as well, and friends too.
We do have a program that allows you to gift Fire membership. So go to Fire's website, go to thefire.org/donate. You can find out all the different ways to donate. Fire gets 50% of our support here at the end of the year. The last 3 months of the year, people are trying to get their tax-deductible donations in before the end of the year. So please consider becoming a member. And if you have the means to, support Fire beyond that as well. We need as many people joining the free speech cause as possible. So as I introduce my distinguished colleagues on this call, I was almost going to say extinguished.
It's been quite a week. I'm not quite extinguished.
You guys are on fire. You're on fire. Please start putting your questions into the Q&A feature there at the bottom of your screen. We're joined by recurring webinar guests, Robert Shibley. Robert is Fire's special counsel for campus advocacy. We also have Will Creeley, who is Fire's legal director, and we are joined by a new participant in Fire's monthly webinars, although you were in a separate webinar last month. Ari Cohn recently rejoined Fire as our lead counsel for tech policy. So welcome, everyone, to the webinar. We received some questions ahead of time, so I'm going to start with one line of questioning that many people have asked. Is the TikTok ban a permissive exception from the freedom of speech? We also have another question. That question's from Steven. We have another question from Larry. I agree with Fire's position that TikTok should not be forced to sell unless the government can demonstrate it is a national security risk. Has Fire consulted with any experts on China to determine for itself if there is a risk? Larry continues, I'm a longtime Fire member who served for 27 years in U.S. intelligence, and I believe there is a 100% certainty that any part of CCP Inc. has to comply with government information demands, and that such demands will be made. Will, you want to kick us off here? Tell us what happened at the D.C. Circuit about a week and a half ago and where things stand now and what Fire's position is.
Sure. And then let me just say I spared you all wearing my Christmas hat today, but I am feeling festive, and I am happy to talk about TikToks or TikToks, whatever you got. Let's start with TikTok. Last week, the United States Court of Appeals for the District of Columbia, just one step below the Supreme Court, they have exclusive and original jurisdiction over the constitutional challenge to this law that was passed by Congress, signed into law by President Biden, and they said it's constitutional. They consolidated the TikTok challenge and the users of TikTok challenge, and they said the act, they assumed without deciding that the act had to pass the highest level of constitutional scrutiny, and they said that it did, that there are national security concerns here that are so compelling that even this unprecedented step of banning an entire platform of communication passed First Amendment scrutiny. Now, just yesterday, folks may have heard in the news that TikTok has filed with the Supreme Court asking the court to issue an injunction and then review the constitutionality of the law itself. Fire, breaking news for all you members and would-be members on the call, Fire will be filing with the Supreme Court today, encouraging the court to indeed grant an injunction and take a look for itself at the constitutionality of the law. So that answers, I think, just the table setting to Stephen's question. Fire's position is that no, this is not within the limited exceptions to the First Amendment. When the government bans a speech platform used by 170 million Americans, it's just about half the country. It's got to do more than just say there's a national security concern. It's got to prove it. And we didn't see anything in the public record, which is all the D.C. Circuit relied on, that would amount to anything more than conjecture, either with regard to the two concerns that the government identified: manipulation of the content on TikTok and data security. And that's our brief, which we'll file today, and you can check it out at our website, argues both concerns are pretty much conjectural. The D.C. Circuit itself admitted that there was no specific intelligence as to whether or not China was manipulating the content on the website. On the app. And as for the data concerns, we raise a number of points in response there. If the act is targeted just at data, it could have done far less sweeping restrictions on an entire expressive medium to address that concern. It seems like it's targeting TikTok because lawmakers didn't like the speech on TikTok. In fact, there were statements by lawmakers on the record. So long story short, the thing acts as a big prior restraint on speech. It's an unprecedented step, and FIRE will oppose it. The government has to put up when it's trying to take a step that big.
Ari, did you have anything else you wanted to add there?
Oh, Will stole my put up or shut up line. That's but just to reiterate that, this is not some small thing. This is quite unprecedented. And the fact that the DC Circuit not only just gave the government a massive amount of deference, but also said, well, they haven't proven that it happened or it will happen, but it's a maybe. It could possibly happen. That just cannot be enough for the magnitude of what the government is doing here. It has to be more than just some hypothetical, we are worried that such a thing might exist. Imagine trying to restrict speech in any other context based on some hypothetical. We are worried that maybe someone might react violently to this speech. We are worried that maybe someone might throw bottles at you. Nobody would agree that that is sufficient. So I don't think we should put up with it here either.
Yeah, it's worth noting, and Erwin Chemerinsky wrote about this in an op-ed. This is the first time, I believe, that the United States government has banned a speech platform. Full stop. And we've been concerned at FIRE for years now about the banning of speech platforms internationally, whether it's X in Brazil or China or Russia banning many of America's social media platforms. In all those cases, it's done on national security grounds. And national security justifications for banning speech date back to the early days of American history, and many of those justifications we now look back on as wrong-headed, whether you're looking at John Adams' Sedition Act, which was justified based on the quasi-war with France, or you look at the Espionage and Sedition Acts that were passed during World War I, which jailed thousands of Americans for opposing America's entry into World War I or the draft. Or you go to the Pentagon Papers case, revealing information about Vietnam. All those free speech cases dealt with national security justifications. There are a couple of things that the government likes to come in based on a conjectural theory, justify censorship. And what is our job as civil libertarians? Remember, FIRE is a free speech organization. Our job as civil libertarians is to hold the government to a high bar when it's trying to use a national security justification to censor speech. And that's what we're doing here. There was a sealed record in this case, and we thought maybe there might be something in the sealed record that the court would rely on to justify banning TikTok. But no, it said everything that it was using to justify its ban and upholding the law was in the public record. And for us, that's just not good enough.
One more quick note, if I may, Nico, just to jump in here. This is slightly beyond FIRE's ambit, but I still want to make this point. When we expanded, we put up billboards around in certain cities that said something like, was it banning speech doesn't make you China, but it's a red flag? I feel a little bit the same way here, right? You don't want to oppose a totalitarian adversary by becoming a little bit more totalitarian yourself, right? As a justification that will be seized upon by dictators and would-be foes across the globe to say, look, America is not really the liberal shining beacon of liberty on a hill. So trampling that quote, but you know what I mean? That America doesn't really mean what it says. They'll ban free speech anytime they find it convenient to do so. I want to stick to our principles here and lead by example.
Sabrina asks, with Ari on staff, welcome Ari, will FIRE focus more on litigation and social media internet cases or just public and government advocacy? Will?
Ari's going to be our jackknife. I gave Ari, what did I assign you on day one? Something like write 800 words on Section 230, and quickly that got
Anderson. Yeah,
Anderson, the Third Circuit's opinion in Anderson, holding social media platforms liable to parents for fads and the harm that might happen to minors for following TikTok fads. It started out from a tragic death of a young woman. And I said, Ari, let's go with something about that, because that's a dangerous theory that's taken hold in the public discourse, that, speech is something like a product, like it's like a liability concern, that, a dangerous speech is the same as opening a bad can of tuna fish. And if you get really sick, then you should be able to hold the speaker liable in the same way you'd hold the canner liable. I mean, that's, if we start indulging that theory, good luck. And maybe we can talk a little bit about that with Donald Trump too. But long story short, Ari's got a billion things to do. We've had him tasked on any number of things, and he's busy. Would you agree, Ari?
I love the chaos. This is what I live for. This is great.
Yeah.
But yeah, we'll try to do everything that we have the time to do. It's just always a matter of having the people with the time to do it. Anyone who knows FIRE knows that that's a premium.
Yeah, Ari will talk in a typical day. Ari, you will talk to allies, you'll talk to media, you'll talk to lawmakers, you'll talk to us, you'll look at briefs, you'll make arguments. We'll put Ari to work. He's our, I would say, utility infielder, but that doesn't quite capture it. How about an all-star outfielder who can play any position on the diamond?
Pretty good with second base. That's fine.
There you go.
We have a question from Melanie. Where a U.S. university has banned mandatory DEI statements, has any department within such university ever successfully mandated these for department faculty members? On what basis or bases? Robert, you want to talk about DEI statements here?
Yeah, I mean, I guess the quick answer to that question is for universities that have, there's different levels of sort of bans on DEI statements. There are some universities that have said they are just not going to require them as a matter of course anymore, and they're going to leave that up to the different departments. And there are the universities that have said no, nobody's asking for DEI statements. So I don't know of any school where the school has said, look, nobody's allowed to ask for these DEI statements, and the departments have gone ahead and done that. So I think that's the quick answer to that question.
And so folks who are new to the conversation are aware DEI statements are diversity, equity, and inclusion statements that require faculty who are applying for a job at a university, are seeking promotion or tenure, to issue a statement on how they will advance diversity, equity, and inclusion on their campus. And we've seen some examples of this weeding out up to 70% of applicants in the University of California system, for example, before their application is ever reviewed on the merits of their scholarship, for example.
Yeah, and sometimes these are required in their annual evaluations too, or for not just for tenure, but they'll be asked. I think we got a case submitted just today where somebody was asking about, I'm supposed to say this particular thing, DEI statement, how much room do I have here to interpret DEI, interpret inclusivity the way I want, or do I have to follow the university's sort of prescribed beliefs? And so that's the fundamental problem is, while it is, you can sort of understand why, if you really want to prioritize diversity, equity, and inclusion, you would ask people that, because if you ask to measure it, you're going to get some more of that. But at the same time, it does act as a very, it has been proved to act as a very effective filter based on politics. And so it ends up, unfortunately, being a litmus test, I think, more often than not.
And faculty see it as such.
Right? And faculty, there's no question from our faculty survey, it just came out now, and Malvi, it looks like, might be dropping it in the chat, that faculty also see it that way. And that, while even liberal faculty are more or less divided on DEI statements. Overall, the overwhelming consensus is that faculty don't believe there is a reason to be asking for DEI statements, and that makes sense. I should give
like 90% of conservative faculty think they're political litmus tests.
Yeah, and even close to, I think, 30 or 40% of liberal faculty. So there isn't that much mistaking about what's going on here, and it's good to see that faculty members are aware of that.
Yeah, we also, Robert, to stick on the subject, got a question from Luke. How does FIRE plan to address forced speech as an issue intimately related to free speech? Examples would be DEI or social justice statements on applications for jobs. Luke is a member of the medical profession and has seen this percolate in his industry as well. Robert, can you talk about the relationship between DEI statements, or forced speech, as Luke puts it, and free speech? Are they one and the same, or
yeah, well,
if not identical twins maybe?
Yeah. Well, they're definitely not. I mean, forced speech. So I guess to start out, forced speech has always been something that FIRE has been opposed to. Early on, we thought of this more in the sort of context of thought reform. And in the earlier days of political correctness, there was, people were urged, I think more often than they are now, to actually literally take diversity pledges and things like that. They would go through trainings that were, very coercive. Sometimes people would come out crying from them, et cetera. And that sort of died off and then seems to have come back in a different form. But we've had a number of cases over the years where I'll give you an example. Schools will they'll say, all right, you have to do your yearly diversity training, and it's online. And so you go online and you can't register for class until you've filled out this survey. And so it tells you about diversity, and then it'll ask you a series of questions, and you have to get them right, or you have to get a certain number right to pass. And when those questions ask something along the lines of, what is the right thing to do here? And then the right thing to do is this very politically overdetermined, make sure you always think about, whoever you might be talking to and their subjective response to it before you talk, when, on these divisive issues like gender, sex, race, etc. That's the kind of thing that we say, no, that's coerced speech. You're saying that literally I cannot register for class unless I say that is the correct way to believe about things. And so we've always been opposed to that. And I do think it is, as we've expanded, we probably will eventually, the world outside of campus stuff is so big. I know that it is a big issue in the medical profession right now and things like that. So I think that's something we'll be working through. But coerced speech is, it is in many ways the antithesis of free speech. And there's a lot of things you can say are even worse. Prior restraint is one of them, when you can't even start to say it. But I think another one is, dictating what you must say, rather than what you must not say or cannot say or should not say. It is very intrusive on your own conscience.
Yeah, that's how George Orwell's 1984 ends.
It is. That's exactly right.
Gin-streaked tears. Mm-hmm. Going down his face. Yeah.
Mm-hmm. We have a question from Ricky here. On January 15th, SCOTUS will hear the case regarding Texas's age verification law. Will you discuss the possible outcomes and discuss whether this case will impact age verifications already in place across the country? Ari, you've been making the rounds across the country talking about age verification and its relationship with free speech and the First Amendment. You want to take this one?
Yeah. So, the district court in that case came up with a really, really good decision. And I say that partially because I wrote an article about that case, and the opinion basically mirrored my article, like word for word. And I felt very proud of myself.
Can you roll back a little bit? Yeah. What's the case? What's it about?
So the case is about a Texas law that targets technically commercial sites that offer more than 33% pornography. And it required two things. It requires age verification, and it also required these disclaimers about these warnings about what porn does to you. I never knew you could lose weight by watching porn, but that's
in 14-point font, right, on every page.
And age verification requires you to submit something that proves your age before accessing the content.
Right. And the district court had a great opinion saying, listen, yes, times have changed since we held age verification unconstitutional back, 20 years ago, but nothing has changed materially enough to change that outcome. Age verification is still unconstitutional. And as well, these warnings are compelled speech, extremely unconstitutional. Fifth Circuit takes it up. They agree on the warnings, which kind of surprised me. But they reversed the district court on the age verification part. And the decision was tortured, in my opinion. But the court basically held all speech related to sex to the standard that, kids, that you can restrict that kind of material for kids. So adults are now held to the same kind of constitutional standard, the lower standard that the government has to satisfy when regulating for kids. Really kind of just misplaced the analysis. The Supreme Court will take it up. I am hoping that they continue to be sick of the Fifth Circuit's shenanigans and send it back down saying, no, you did this analysis wrong. Strict scrutiny, the most rigorous constitutional scrutiny is what should have been applied here. But it's hard to tell because sex is different for a lot of people. It makes people think differently about issues they would feel otherwise about if sex were not involved. That is just a reality.
Let me jump in here real quick with two additional points. First of all, to Ricky's good question, if the Supreme Court upholds the, in Fire's view, terrible Fifth Circuit opinion, it will be at odds with every other district court to consider the constitutionality of these age verification laws. They've been routinely enjoined on First Amendment grounds because they burden adult access to protected speech. We're not talking about obscenity here, something that's beyond the First Amendment's protections. We're talking about adult content, and sometimes very vaguely defined adult content that is protected by the First Amendment. So when you make grown adults jump over a hoop in order to access protected content, you've got a First Amendment problem. So every other court has found this way. The Fifth Circuit is the outlier.
Including the Supreme Court.
Including the Supreme Court, as Ari alluded to 4 times just a generation ago. I mean, I don't even know if 20 years is a generation, but so this would be a big break in First Amendment jurisprudence, and it would effectively overturn those good holdings in other states. The Fifth Circuit's the outlier, and Fire's filed a brief with the Supreme Court trying to keep it that way.
Yeah, the effect here is that you need to turn over your government ID to access constitutionally protected speech. And it's not like just turning over your government ID to get a copy of Playboy at the newsstand. This is actually going to log your information, right? As it would have to, because if the companies that are required to do age verification need to demonstrate that they are complying with the age verification, they need to have a log of who accessed their website. And as we have seen in the past, many social media platforms, even the federal government itself, this data has been hacked. It will be hacked almost certainly, and it'll be used as a political weapon. It's funny. We're worried about people essentially.
Yeah, we're worried about data security with regard to TikTok, but given the government list that everybody's visited a porn site.
One of the things I find interesting also is back in the old cases, back in the early aughts, late 90s. One of the things that the court said is this age verification back then was an affirmative defense to a statute, and the court said this is effectively unavailable because there is no real way to verify someone's identity over the internet. Back then, it was done by credit card information. And I think, in my opinion, the same thing is true now. On the internet, nobody knows you're a dog. It is just as easy to take your brother's driver's license and submit it to the website. It is very easy to trick selfie verification. There is actually no way to prove that whoever is putting in that information is the person that they say they are. It's just almost impossible over the internet to conceive of a way to really do that. One difference I do want to note is if the Supreme Court does uphold this, it does not necessarily affect age verification laws with respect to, say, social media. It's very possible that we could see decisions at odds, one for pornography, one for social media. I hope that's not the case, but I could see it happening.
Question
2025, what interesting things you may hold. We shall see.
Sabrina asked, do you have thoughts on states using, quote, addictive features to regulate minors' access to social media, to avoid making the regulation content-based. I think Ricky, I'm scrolling up here, asked a similar question. Would the bans on social media for young people be a First Amendment violation if it's government mandated? So we are getting now into the social media access for young people. There's been a big debate across the country since Jonathan Haidt's book came out earlier this year, The Anxious Generation. I just saw on social media that it sold 1 million copies as of, I guess, this week, Penguin announced. So people are definitely concerned about the effect of social media on young people. And there's been debate in Congress over the Kids Online Safety Act that would regulate how social media is presented to kids and how kids can access social media. Ari, do you want to take the lead here in explaining what
I'm going to try and speed run you all through this?
Some of what let's try and speak broadly here about some of what it's trying to do, because it's not just COSA and the federal government that are trying to mandate some of these approaches to regulating social media access for kids, but we're also seeing it in the states as well. So it would be helpful to articulate what those arguments are and how FIRE views them from a free speech First Amendment perspective.
So to take Ricky's question first, because it's an easy one, yes, banning kids from social media is absolutely a First Amendment violation. Minors have First Amendment rights, and for good reason. Judge Posner put it probably the best way I've ever seen it put in a case called American Amusement Machines versus Kendrick out of the Seventh Circuit, where he went on a multi-paragraph spiel about how children are not, they don't pop out at 18 and automatically know how to navigate the world. They have to have training wheels. You have to actually raise them with getting experience for them to become productive members of society at 18. You cannot just toss an 18-year-old into life without any context or any experience and expect them to do anything but flounder. And I think that is especially true with social media. Imagine, we joke about Nigerian print scams, but can you imagine an 18-year-old logging on to Facebook for the first time at 18, having no idea what's going on, and they're going to get suckered by all kinds of different things. Terrible for media literacy as well. To go on to COSA, and some of its analogs. The big thing about COSA is trying to prevent certain harms to minors, eating disorders, suicide, depression, anxiety, things like that. The problem is a lot of that content is entirely constitutionally protected. Just because it might be harmful does not make it unprotected. And it's difficult to regulate. So what they have tried to do is say, okay, you have a duty of care in your design features. So it's not necessarily you are liable for the content that people post on your site. It is the design features that you then use to feed that content to the minor users, which is really a distinction without a difference. If you say you have a duty to prevent or mitigate, say, eating disorders in the operation of your recommendation algorithm, well, the recommendation algorithm by itself, devoid of content, could not possibly cause an eating disorder. It can only be justified with reference to the content that the algorithm serves up. So it's very clearly still directed at content. And the proposition, first of all, if you don't trust social media platforms in the first place, saying that they now should be responsible for preventing and mitigating serious harms to your child seems crazy. Second of all, kids are not a monolith. They experience content differently. They are individuals, and they also, from the age of 10, the age of 17, are very different experiences in life, can handle different levels of content. And what it basically is forcing the platforms to do is either A, know what's going to affect each individual child in a particular way, impossible, or B, make decisions based on kids as this just blob of a group and what might be harmful to them, which is possible, but entirely unhelpful due to the differences in, individuals and age ranges. And, to touch on the addiction thing for just a second, I find it very, very troubling that we have moved to a point where we are starting to talk about regulating addiction to ideas. And that's really what this is, addiction to speech. Yep. The entire purpose of media, of every single form of media, is to get your attention, and keep it. That is the whole point. Choose Your Own Adventures books do that. Like cliffhangers at the end of a season do that.
Quote unquote binge watching. Yeah.
Yeah. So the idea that we can, punish people for creating content that people want to keep consuming is just extremely troubling to me.
And the question of whether minors have First Amendment rights goes back to Justice Antonin Scalia writing in a case involving access to violent video games. Justice Scalia struck that down with the court's majority in that case. It was a California law that regulated the age at which
footnote 3.
Yeah, which minors could purchase video games.
And we were just talking about age verification. These efforts to address design features would incentivize and functionally require age verification, because the platforms would now be on the hook for understanding who their users would be. So there goes anonymous speech for adults, right? There goes the unburdened access to protected speech content online that now marks the internet. Yeah, it's a big European-style regulation of speech here in the United States that doesn't pass constitutional muster on a number of fronts. However well-intentioned, the obligation has to still be with the parents and the children themselves. There's no one-size-fits-all government mandate that's going to address whatever problem social media may or may not be causing.
I know many of our members have concerns or have had concerns historically with social media censorship. If you hated social media censorship and how these platforms moderated their content, this is only going to supercharge those concerns, because it's going to saddle them with excessive liability, or very burdensome liability that's going to just push them to be risk averse and take down content. What this law is a European style social media regulation. And if you don't like how Europe and these foreign countries have approached social media regulation, we shouldn't try and emulate it here in the United States. So where the law stands right now, or the bill, I should say, stands right now, it was passed in the Senate. It's being held up in the House. It doesn't look like it will be moved for a vote before the end of this Congress. So Mike Johnson, the Speaker of the House, has talked about revisiting it in the new Congress, has expressed some concerns about its implication for free speech, and hopefully there are changes to it that would address the extensive free speech and First Amendment concerns, and FIRE will be on the lookout and will provide commentary.
The change I would suggest is dumping it in the trash and starting over again.
I just add, I think I'm the only one of the four of us who actually has kids who are right smack in. I have a 16 and 14-year-old daughter, right? And so for me, this is a very real concern. I personally don't let them I don't let them have accounts on social media. Obviously they see posts and everything. They're always sharing it on text. I do let them text, etc. Kind of wish I hadn't sometimes, but hey, it is what it is. The thing that really, so I am very sympathetic to the concerns of people like Haidt and other parents who are concerned, because it really is like I think it's hard to viscerally understand how threatening it can seem, like the power of that culture that's coming through these social media things. But the thing that really tips it over for me is that the fact is that we know the government will abuse any kind of age verification system to pierce your anonymity. And I know it can be tempting to say, like, well, the NSA is already reading all of our mail anyway, and that's probably right, etc. But giving them more legal cover to decide to go after anonymous speakers or people who just would prefer not to be destroyed legally or in their job that's a power that we can't afford to give them.
Steve asks, Ari, while it is currently impossible for websites to verify the identity of people who are posting, couldn't an app be developed which would allow people to validate their identity online? So you've seen this argument proffered.
Yeah, and I was actually just typing an answer to that. The problem is, again, when you're doing it through a mobile device and there's you on one end and a machine on the other end, there really isn't a way to tell who is putting the information in, whether they are the person they say they are. Take, for instance, the selfie verification. You have to upload your driver's license and then take a selfie. Well, first of all, again, if I have my older brother next to me, I can have them do it and then just hand my phone back to me. But I could also take their ID and I am not joking. If you go on Google and search for how to fool selfie age verification, the first page has at least 10 links that will tell you how to do it easily with free software that like any modern 12-year-old can figure out.
They're going to tell us we have to block that on Google. Come on, dude. Think about it.
I haven't seen a solution yet that really gets around the problem of like not knowing who is handing the information. When you go to a bar, you hand your driver's license to the bartender. They can look at the license, look at you, see it's the real person. That analog doesn't exist when you're doing it digitally, and I don't know how to get around that.
Trina asks, the huge problem and prevalence of citizens' First Amendment rights being violated while making comments during public comment periods of city, county, and school board public meetings. Does FIRE have the interest, will, or resources, including possibly availability of interns who could work on it, to proactively go state by state, county by county with letters warning these government entities about citizens' rights so these incidents stop happening?
Let me take a swing at this one. Yeah, Trina, if it's the Trina I'm thinking of, Trina, thanks for tuning in. Thanks, as always, for your support. Trina's given us some good leads on cases over the last few months, and I'm grateful. What we've tried to do, our public advocacy team, headed by Aaron Terr and his good folks over there, they will write in whether it's props being banned, and that includes the American flag at Edison, New Jersey, which is a recent victory of ours.
We have a question about that too.
Okay, we'll get there. Or our client, Rebecca Massey, being let off in handcuffs. Just a shocking case. I can't even talk about it without getting angry in front of her 10-year-old daughter in Surprise, Arizona. Yeah, we're going to keep fighting this fight to make sure that either town councils, state legislative bodies, they have to be able to deal with the fact that citizens are going to petition them for redress of grievances, and they're going to exercise their First Amendment rights and show up at public meetings and do so. Are we going to go state by state? Well, what we've done in public advocacy is when we win a victory, we will use an old method that we used to use on the campus context. We'll write other schools in campus when we won one of our cases, and we'd say, hey, look what the folks down the road are doing. You should do that too. And we're starting to import that model into our public advocacy work to kind of multiply the effect of these victories. And we do think that a little bit of publicity here has a strong deterrent effect, and folks will do the right thing. They don't want to be on the nightly news like the town council in Edison, New Jersey was. They want to get it right to start. So stay tuned. We got more to come on that front in 2025. And Trina, thanks again for your support.
And what happened in Edison, New Jersey, Will?
They banned, they had a broad ordinance that prohibited the use of props for citizens coming to speak out during public comment periods of their town council meetings. And that included the American flag. And a copy of the Constitution.
And
a copy of the Constitution. So many fire cases, actually, this is kind of a fun fire trivia fact. So many of our cases involves people for years, students handing out copies of the Constitution or just wanting to hold a copy of the Constitution. I think instantly of our guy, Kevin Shaw, who was a plaintiff in our lawsuit against the community college in Los Angeles, who was handing out Spanish language copies of the Constitution. And he was doing it outside of the free speech zone, which is about the size of a parking spot. And he got busted for that. We won that lawsuit. But yeah, Edison, New Jersey, they're trying to crack down on props during public meetings without the necessary fact of disruption, right? We're just saying blanket ban on you bringing anything here. What if it's a photo of the time that the town garbage truck dumped all that garbage in front of your lawn? You can't bring that and show the council and say, hey, look, we got a problem here. I mean, come on. You just can't do that. So Edison looks like they're on the path to getting it right. We're going to find out for sure next month when they meet and modify or repeal that ordinance that banned props. And we'll do that. I mean, we're here for the long run. And if you know folks who are dealing with these kinds of issues, send them our way.
We sent the town council in Edison a letter, and the council held that up at the meeting that evening and said, we're gonna reverse this prop ban because I got this letter here from FIRE, and now just the way that city government works in New Jersey, I think it takes a couple of meetings for
you got to notice it. Yeah, you got to notice it, and you'll do it at the next meeting. But I have no doubt that they do not want to be on the wrong side of that one, because who wants to fight against the First Amendment? I mean, come on.
We also had a mobile billboard, and our activism team was out there handing out FIRE T-shirts. It was a fun day, although I guess it was raining too, which rained on our parade a little bit.
Part of the fun here for us, I think I speak for all of us on the call, is that there's an educational component here. I mean, we're laughing about it. It seems ridiculous, but until First Amendment rights are made real for folks until you really feel it. Like, hey, you're telling me I can't have this flag at a public meeting in my own town? I mean, I thought this was America, people. Until you're on the wrong side of that, you don't realize it. So FIRE's job is to make the First Amendment real in your life so that you understand and you educate folks around you that, no, if I stand up for these rights, there's an organization that's going to back me. That's where we come in.
I just want to bring up a profound piece of the wisdom of our founders in adding the right to petition the government for the redress of grievances. We used to joke a little bit about that at FIRE. We're like, yeah, we need some right to petition cases. That's one of the 5 parts of the First Amendment we never get. And now it is amazing. And I think actually it may have grown in part out of the way colleges treat things too much, but the lengths to which government agencies and authorities will go to avoid even being asked questions that they don't want to answer, even when they have the authority to just listen to the question, answer you, and do nothing about it. It is amazing the lengths that they will go. And now that I've brought that up, I think everybody on here will see it. You'll be like, they're just trying not to answer the question, even though they could totally get away with it. That is the playbook universities have been using forever. And it is totally destructive to having a participatory democracy. Yeah, well.
Damn right, Robert. I got breaking news here, one tab over from our colleague Aaron, who I referenced, who heads up our public advocacy department. He says, I'm almost done with a template letter to 20 Michigan cities with problematic public comment policies, citing our litigation victory in East Point and the Sixth Circuit decision in Ison. He says, you probably won't see this in time for your answer, though. There you go. Thanks very much, Aaron. I appreciate you tuning in as well.
One of the things that you find when you litigate cases, especially ones that become high profile, especially ones that have video, which are more likely to make them high profile, as many of these town council censorship cases are, is that you get more of these cases that come your way. And FIRE has grown, but we are not big enough that we can take all of these cases, although we hope we will be one day. We've only expanded off campus for, 2.5 years now? So
we're like a busy deli counter. Take a number, we'll get there. But I tell you what, we're cranking through. I mean, those folks over in public advocacy, they won that case in record time. It's like 24 hours? It was quick. It's real quick. We're going to keep doing it too.
Emily asks, restrictions on social media access seem to be the way to deal with the addiction that social media can cause, but that would be a violation, as we've discussed, of people's free speech rights. If social media cannot be dealt with like drugs and other addictive substances, how can social media addiction be dealt with? Does anyone want to take that? Ari?
Well, it's important to recognize that the reason that we can't deal with social media like we do, say, cigarettes is because the right to smoke a cigarette is not enshrined in the Constitution, whereas social media, which is an expressive platform, directly implicates our First Amendment rights. So I see that tension a lot. People say, well, why can't we just regulate this like big tobacco? It's because different things are different. It all has to come down to parents being involved, parents knowing their children. And I know this sounds kind of careless in a sense, because parenting is hard, and parenting today is extremely hard. And I am sympathetic to that. But
why do my kids have to know what
life is hard?
City party? I didn't tell them, right? It's like, oh, all right.
I tell you what, I mean, again, as Ari says, the big difference is that this is speech. We're talking about speech. We're talking about words. We're not talking about tobacco or some kind of,
Well, and how successful have the efforts against drugs and tobacco been? I mean,
that's right. It's a great point, Robert.
About something that's something you can grab somebody's cocaine or heroin or fentanyl or whatever, but I mean, you're right. It's an idea.
Let me recommend folks to the great Substack called Pessimists Archive, which Nico put me onto some months ago. It's great. It rounds up contemporary accounts of what we would now call moral panics, whether that's about video games, whether that's about photography. People were worried that photography would usher in what, the same kind of concerns we now have about deepfakes, whether that's about heavy metal music or comic books. And when you see in the fullness of time, with the wisdom of the decades passing, that every generation is going to go to the ramparts with worry and anxiety about what's happening to kids these days. And it's not to lessen the very real anxiety that a parent like Robert or a parent like myself has about kids. It's always hard to raise kids. But at the end of the day, there's nothing that's ever going to beat. There's no government regulation cure that's ever going to beat just talking to your kids and trying to be as present, as involved as possible. I truly believe that. I remember, folks freaking out about rap music or, PlayStations or whatever the hell it was. And I don't know, we made it out okay, right, Robert? So
free societies are hard. I mean, we fool ourselves into thinking that they're not. Like, North Korea is probably very wholesome childhood wise, I would assume, in terms, like, depending on your version of wholesome, how much Kim Jong-un is in it. Like, you're probably not getting up to too much mischief, right? But I don't think we want that.
That's perfectly stated. That's right, Robert.
I think it's also kind of important to not delude ourselves into thinking that we can create an entirely safe internet. There's always going to be dangers. Crossing the street is always a danger. Nothing is 100% safe. And the more we try to legislate or regulate our way into total safety, the more blind spots we're going to create for ourselves. And that ultimately doesn't serve us well.
Question here. Corporate media threatens the freedom of the press after Donald Trump. Does this put an impact on the freedom of speech? This might actually give us an opportunity to discuss the recent lawsuit filed by President Trump against the Des Moines Register and Ann Seltzer over the polling that they did in Iowa leading up to the presidential election, where Ann Seltzer and the Des Moines, Iowa poll, which has been held by many pollsters to be the gold standard poll. If I'm recalling correctly, it predicted that Kamala Harris would win by 3 percentage points in the state of Iowa. This was a surprise to a lot of people. Donald Trump ended up winning the state of Iowa by something like 13 percentage points. The poll got it wrong, wildly wrong. Many polls have gotten the Donald Trump campaigns wrong going back to 2016. He's now arguing that this poll was a form of consumer fraud. And Fire has posted a statement arguing that running polls for a newspaper is First Amendment protected activity. There's no exception to the First Amendment for getting a poll wrong. But folks are arguing, well, there might have been some malicious intent in the background here. Let's get this case to discovery and find out. Or that this was deliberate election interference. What do we as free speech First Amendment advocates make of that?
I tell the President-elect's got to toughen up a little bit. There's going to be a lot of speech out there that isn't like in a lot of newspapers. That's America. That's the way it's been. That's the way it's always should be. When we were working on that statement, I said something like, from 1776 to 2024, a free press has kept America great, to use the lingua franca of the president-elect and his supporters, and that's the way it should be. And then my colleague J.T. Morris said, well, what about John Peter Zenger in the proto-revolutionary period? So I want to give a shout out to John Peter Zenger as well. The free press keeps us honest, and you're going to see stuff in the free press that you don't like, whether that's a poll that gets the numbers wrong or an interview like the one with Stephanopoulos that ABC recently settled over. And we got to watch out here. The president-elect is on record saying he wants to straighten out the press. And if that means filing baseless lawsuits about protected speech, Fire's going to be on the case.
What's the problem, Will? What's the problem, Ari and Robert, with filing these lawsuits and seeing what's there, right?
Well, first of all,
that's the argument. That's the argument on the other side, is that we suspect there's something going on here that might violate, in this case, a consumer protection law.
There is absolutely nothing that they could possibly find that could remotely, even plausibly, be a basis for this lawsuit. It will be a miracle if the lawyers don't get sanctioned. It is, even if there was malicious intent and they said, oh yeah, we're going to put out this fake poll, guess what? That's also constitutionally protected, because lies are not ipso facto devoid of constitutional protection. They can be defamatory. This certainly was not. But just publishing a poll because you want to hurt someone's campaign is no different than publishing a news article saying this person is a terrible candidate for X, Y, and Z.
Yeah, let's say The Onion ran a poll 2 weeks before and distributed to every household in Iowa saying that Ronald McDonald was polling at 240% and all the other candidates were at 0. We would laugh this out of court, right? And we're talking about a respected pollster who's gotten way back. Getting a poll wrong is not the equivalent of product liability fraud, right? It's not election interference to get a poll wrong. Even if, and as Ari says, even if you go in and you say, oh, look, their sample size is undersampling Trump supporters, and that's how they got this. Even then, you're not there. Wake me up when they run something that says like, "Hey, Trump supporters, election day is actually, the day after. It's actually going to be on that Wednesday." Then maybe we'll have a conversation. But even then, I doubt it. Robert, you want in on this?
Yeah, I mean, with regard to the consumer fraud thing too, I mean, my understanding is that she was doing these polls for the Des Moines Register. So let's say that Seltzer took a bribe and just defrauded the poll, just made it up or whatever. I think what a court would say there is maybe somebody did get defrauded, but it's the Des Moines Register who is paying for the poll. So, I mean, now look, that would obviously be, I can understand why people will be concerned that, pollsters who are respected, if it turns out they're taking payoffs, et cetera. But, even though I spent a couple years in private practice, I have a certain amount of sympathy to the man, I know these guys are up to something. Let's get them to discovery and see what it is. It's not really supposed to be the way the legal system works, is just so you can go rummaging through other people's emails. That we would not like it if that were the rule.
No, it's practically a strategic lawsuit against public participation. It's designed to chill the free press. It's designed to get people to shut up or think twice before they run a poll with numbers that a powerful person doesn't like. It's un-American.
And Will, just to talk about that, SLAP, strategic lawsuits against public participation, these are cases that Fire has been involved in over the past couple of years. Right. These are essentially efforts by people to shut up their critics by filing lawsuits, often frivolous. And
it's censorship by suit. That's right.
Censorship by lawsuit. You tie people up in litigation. You force them to spend a lot of money. You make them scared to speak out because what other lawsuit's going to come down the pike. And even the people who are filing lawsuit, often with deep pockets, know they're going to lose, but it's the process that's the punishment. And that's why you have states across the country that have passed so-called anti-SLAP lawsuits or anti-SLAP laws to protect against these sort of lawsuits, to make them less damaging for the defendants. But my understanding is Iowa does not have an anti-SLAP law.
That's right. And I want to pause for a second here and take this opportunity to recognize one of our brave plaintiffs who's here today in the chat, Gary Gadwa, who just got a tough ruling from the Idaho Supreme Court, but we still got your back, Gary. We're going to keep fighting for you. Folks can check out Gary's story on our website. Maybe we'll throw a link in there. But as Gary says, I firmly believe the size of your voice should not be dictated by the size of your wallet. Right on. Yeah, everybody's got a First Amendment right, whether you are a billionaire or a pollster or a newspaper or Gary in Idaho. And we've got your back, Gary, and we're going to keep fighting. Gary was the subject of an anti-SLAP suit, and we're still representing him in court. So that case is ongoing. But yeah, just as you say, Nico, the process is the punishment here. It's censorship by suit. It's designed to make folks think twice before saying something that might offend somebody in power. And again, I will reiterate, it's un-American, and we'll keep fighting against it.
Yeah, and Ricky says, frivolous lawsuits, won't they start getting thrown out of court? Yes, most likely. But the thing a lot of people don't realize is the cost of getting it thrown out of court can be enormous. In federal court, the average motion to dismiss is about $25,000 for a single count for a basic lawsuit. It can be extremely expensive just to get to the point where you get it tossed out of court, and that's why this tactic works.
A question from an anonymous attendee: how do you distinguish the freedom of speech versus freedom from social consequences? This is speaking to a lot of the debate that happened during the height of so-called cancel culture. Robert, you maybe want to take this are social consequences a form of freedom of speech?
Well, I mean, they are. So I would first recommend to everybody, and I always do, is On Liberty by John Stuart Mill. Chapter 2 is the only one you really need to read, but he talks about this, and it's probably the most readable philosopher that's out there. But he talks about this and points out that, I mean, the sort of easy answer, and one of the correct answers, is that when it is the government doing it, or people, who have been put in authority in an official sense of the ability to punish you, that that's when the freedom of speech, you should be free from consequences, official consequences for what you say. And that's kind of like the easy mode answer to that question. The harder one is, what does it mean when you have a culture that is so hostile to what you are saying that you get these consequences that seem wildly out of proportion to what the offense is. And admittedly, what seems out of proportion can vary widely. But Mill points out that he talks about the difference between England and France. France at the time had more restrictive laws, but he noticed that people in France were willing to talk about more controversial things than England. And I think that I'm paraphrasing here, but he says, you don't need a law to ban somebody from saying something if you can just prevent them from having a job if they say it, prevent the baker from like the means to make his bread, or however we put it. And so, you cannot draw a bright line there, because you do want there to be some social consequences, because you can't have a marketplace unless things are valued greater and lesser, right? And so you have to have some of that. But can people coalesce around the idea that generally speaking, if your job has nothing to do with what you're saying, maybe you shouldn't lose it for that? I mean, that's the kind of thing that you would find a lot of support for. But I'll tell you what, it is so easy to do it when it's people who agree with you, and so difficult when it's people who don't agree. Like that Home Depot lady, I can't believe she said that thing about Trump or Biden or whoever it was.
Yeah, it was after the assassination attempt on Donald Trump. Yeah. There was some lady who was a low-level employee at Home Depot who said something something to the effect that she wished that the bullet had hit Donald Trump, and people jumped on her and started calling Home Depot and asking her to get fired. I once wrote about free speech culture, which is admittedly a sort of mushy concept. And my definition of it was this. I'll take moderator's privilege here to read it. Free speech culture is a set of norms that support free thought and our ability to share our opinions. These are norms that see value in curiosity, dissent, devil's advocacy, thought experimentation, and talking across lines of difference, where, and this is critical for me, where our first instinct in response to speech we dislike isn't to find a way to censor it or to cancel the speaker, but to meet it with more speech, to defeat ideas we oppose with better ones. So these are norms, of course, but I think during the height of cancel culture, people's first instinct was to win arguments without actually winning arguments, rather to get them fired from their jobs so that they felt like they could no longer speak up because their means of livelihood were taken away. And maybe you feel, and that's First Amendment protected activity. You can definitely go and call someone's employer and say, this person is an asshole. I don't want them to have a job anymore. But is that really what you want in a society where your discourse devolves into just trying to get people fired from their jobs? It's not a society I want to live in. It's not the society I want my two sons to live in. And that's my big
categorical imperative to that. Like, well, what if everybody's doing it kind of thing? Like, you want to live in that kind of society. So I wish it were more distinct.
If you had Kantian categorical imperative on your bingo card for this webinar, you just won. All right, well, let me just real quick just quote Fire's mission, because it's right in line with what both of you are saying. Fire defends and promotes the value of free speech for all Americans in our courtrooms. Check. Campuses, check, and our culture. Our vision is an America in which people overwhelmingly believe in the right of others to freely express views different from their own and expect their laws and educational institutions to reflect and teach this belief. Right on.
If you will indulge me here, we've got about 2 minutes left in the hour. I want to try and get through two more questions. We might go 5 minutes late here. We still have a bunch of people. It's
lightning round.
So people are enjoying the conversation seemingly and sticking around. We'll do two more questions and then close it up. Stephen asks, why would ABC give up in paying off for the Stephanopoulos quote? The suit would never have survived a First Amendment defense given the press's special defenses in these cases. So this is something that we referenced earlier. This is a defamation lawsuit filed by President-elect Donald Trump against George Stephanopoulos and ABC News, where George Stephanopoulos misquoted the civil findings against President Trump as he was found civilly liable for rape when actually it was sexual assault. That's my understanding. They recently settled that lawsuit and promised to pay, I think, $1 million in attorney's fees and $15 million to President Trump's future presidential library. Now, there are many in the First Amendment, free speech, free press community that are very concerned about ABC settling this lawsuit because they believed that it wasn't viable, that it should have been fought out, and that it will just incentivize more frivolous defamation lawsuits that will cripple the free press and chill speech. Ari, I see you shaking your head. Will, I know you've been reading up a lot about this. Does either of you want to start out here and give?
I'm going to take the cop out. I just asked Malvi to send around the best piece I've seen about it. Thank you very much, Malvi. Piece by Richard Toffel, who is a longtime press lawyer and headed up ProPublica for some years. And he asked these questions. We just don't know exactly right now what ABC's motivation was. There were depositions that were on deck. They were supposed to happen. Something is afoot there. Either it's corporate cowardice, or there was something afoot. But those are the questions that ABC should answer for all of us. Otherwise, they've set this troubling precedent of bowing before power, and that's no good. So if there was something there, we should know about it. And I think, as Richard Toffel argues, that ABC shareholders have a right to know about it, and ABC journalists have a right to know about it in addition to the public. So that's a great piece. I highly recommend it, and I'll leave it there since I know it's lightning round.
Ari, did you have anything else you wanted to add there? I would just say that the standard for defamation when you're talking about public figures is that there needs to be a false statement of fact that is made with actual malice or reckless disregard.
Yeah, exactly right. Thanks, Nico. And that's a high standard, so it really does make you wonder what's going on here.
It's just, I'll just say as a general proposition, it really irks me when huge companies with big bankrolls that can afford the litigation roll over like this. It happens, and it has happened when even there wasn't some kind of thing going on in the background. It just happens sometimes because the company just doesn't want to deal with it. And it really kind of screws everyone else over to an extent.
I mean, it'd be very easy for something bad in Discovery to cost Disney more than $15 million in
one hot doc
alone, right? I mean, that's not hard when you're a multi-bazillion dollar company.
Malvi, we have Nishi asking if we can share the link to my Culture of Free Speech quote that I just shared. I'm going to put it in the chat here for hosts and panelists because I can't figure out how to change that. So
another good Christmas present, the collected writings of Nico Perino. I'd buy that. Nico's got a book forthcoming next year. It's too modest to let you know, but as soon as it's out, you can smash that pre-order. We're going to post it up. You can check my Twitter for it. We'll be ready for it.
Yeah, I have a book coming out. It'll probably be 2 years at this point. I got to submit it by the end of the year, but it's looking at the expansion of free speech, First Amendment rights over the past century from the perspective and through the stories of the people who made the expansion of those rights possible. There are a lot of old school civil libertarians who I greatly admire and are retiring from the barricades. I was inspired to begin this work back in 2017 at the funeral of the late, great civil libertarian Nat Hentoff. It's what led me to make a documentary about former ACLU executive director Ira Glasser. And so this book is going to open the aperture on that broader meta project to interview all these folks before they're gone and get their stories. Why did they defend free speech? Why did they expand First Amendment rights? And do they think those rights can endure? Last question here, I promise. As more questions keep coming in, and it scrolls down, Zach asks, this is related to the recent case of a teacher in Iowa creating an unconditional and overly restrictive banned words list. With all the anti-free speech stuff going on in college campuses right now, how are things faring in K through 12, and what can FIRE do? Will, what can we do?
Well, we can keep litigating, which is what we're doing. We can educate. We can use all the tools at our disposal to make sure that free speech isn't just some paper right. That students in K-12 situations, in K-12 schools, know that the free speech is a real thing. Right now, we're litigating before the United States Court of Appeals for the Sixth Circuit on behalf of students who were told that they could not wear Let's Go Brandon sweatshirts they received as Christmas presents. So you can see a blog entry up on our site today about all the friend of the court support we've received from organizations across the ideological spectrum in support of the right of grade school students at our public schools to engage in political speech that's non-disruptive, totally protected by the First Amendment. We'll keep doing the work. We've got a couple of cases right now litigating on behalf of K-12 student speech rights. So I firmly believe that, as the Supreme Court put it in the case decided just a couple years ago, that our public schools are nurseries of democracy, to use Justice Breyer's phrase, and that if we don't teach students about free speech and teach them that it's a meaningful thing, that we really mean what we say when we talk about the Bill of Rights, when we talk about the First Amendment, that they'll grow up and they won't understand it. To quote one of FIRE's co-founders, a nation that does not educate in liberty will not soon hold it and won't even know when it's gone. I think I'm paraphrasing Professor Kors there a little bit, but that's the sentiment. So we are going to keep that work alive. You can ask my 10-year-old and my 7-year-old about free speech, and they'll tell you about it. I remember in that TikTok series we did with me, the one that got by far the most views was me saying that if I ever found out my kids are disciplined for not saying the Pledge of Allegiance at school, I'd be all over it, But they do say the pledge. As my daughter explained to me, she wants to be a friend to the flag, as she put it, which I thought was very sweet. So yeah, no, we're doing that work, and we'll continue to do that work. And if you got cases, send them our way.
I apologize to everyone whose questions we didn't get to. There were 29 unanswered questions. Andrew, I see you there. I'm sorry that you've asked a question during this webinar and the last one. If you come to our next webinar, I will make it a point to get to your questions.
I email them. If you want to work with your college, just give me an email, robert.shibley@thefire.org, and I can connect you. We got resources.
Right. And I'm going to be at my in-laws' place in Minnesota all next week. So you can email me at will@thefire.org, and I will write you back. And I've actually had great conversations with folks I've met through these monthly member webinars. So yeah, please keep them coming. will@thefire.org.
If you're interested in finding this webinar or past webinars, you can find them at the members portal on FIRE's website, thefire.org. Again, thefire.org, just go to the top there. There's a member portal. If you haven't created your credentials to log in, you can do so, and then you can get access to past member webinars. We also give you access to these through the So to Speak podcast Substack. If you are a paying member to So to Speak, you get these episodes in your restricted, members-only podcast feed, which can be accessed through Substack. If you are already a FIRE member and don't want to pay through Substack, just shoot us an email, so to speak, @thefire.org. We'll get you honored on the Substack side. And this podcast, though, because it is open beyond FIRE members to try and incentivize the general public to become FIRE members before the end of the year, is going to be available on, so to speak, the Free Speech podcast feed later this week. And I would just ask you all, if you appreciate the work that we're doing at FIRE and you want to see it continue and you want to see it expand, please consider a donation before the end of the year. They are tax deductible, and they are what makes the work possible. We function entirely on donations and support from the general public, and we could not do it without you. I thank you all again for joining the webinar. We'll see you next month. And in the meantime, happy holidays and Happy New Year.